you, Your Honor. Patrick Evans for the appellant, Ms. Bassi. I had specified 15 minutes. Some would be for rebuttal, but I'm wondering, the docket shows that the respondent waived oral argument. So I'm wondering if there is appearance by the respondent permitted here today.
I don't have that on my calendar.
Well, I'm looking at the docket, January 17, 2024. It says argument waived by respondent, no response. I don't recall ever getting a response. I'm not going to argue the point, but that's just what the docket reflects.
Thank you, Mr. Evans. Let's check in with respondent.
Good afternoon, Your Honor. Christine Collingwood on behalf of respondent Robert Bassi. I did request 5 minutes of time.
Okay. Well, let's go ahead with that. So, Mr. Evans, would you like 10 and 5?
Yeah, that will be fine. In light of the long day so far, I'll try to be briefer.
Well, I appreciate that, but I don't want to cut you off. So feel free to take the 10 and 5 if you would like. So why don't we begin with you, Mr. Evans? Please go ahead.
Thank you, Your Honor. This case has the broad question is, when is an email domestic violence? The trial court essentially specified one email saying that it constituted domestic violence under the domestic violence statutes, the definitions thereof. And that email, when you look at it, it's reprinted at page 20 of our opening brief. In our view, doesn't fit the bill at all to what would be a threat of violence, domestic violence, what have you. And we had pointed out to the court in our reply brief a case that came up between the original brief and the reply brief, the case Hansen, Hansen versus Volkov, Volkof, which is now in the books at 96 Cal App 5th, 94. The reason I bring up that case is the court there reviewing kind of a, let's call it mean interchange between lawyers in a family law case, reversed the trial court for having found domestic violence based on email with the specific point, it's page 10 of our reply, that those communications, quote, did not contain any threats of violence, credible or otherwise, close quote. And in our view, that's end of discussion on this particular case. There's just nothing here. Ms. Bassi and her ex-husband were in litigation for approximately 10 years at the time this arose. She had never been found to have committed domestic violence. There were no DVRO orders. Nothing of that sort had occurred. And at the cusp of finishing this way too long family law case, this happens. And, you know, apart from the just lack of substance, the trial court ruling, the theory, we find to be very just insufficient. The trial court, again, I just reproduced at page 20 of our opening brief. The trial court said that the one email that the trial court ruled was somehow constituted domestic violence, was not anti-SLAPP protected, that email did not convey information about the family law proceedings or the related seed RICO matter involving the community businesses, and that it didn't engage in relevant discussion. Well, assuming that's true, it did not convey information, it did not engage in relevant discussion. There can be all types of communications that don't fit that bill and still would be litigation privileged under Civil Code 47 and anti-SLAPP protected. I mean, people in litigation say mean things to each other all the time. And the fact that they do so is natural to the process. And of course, I think all of us attorneys and judges would agree that there's been problems with counsel and so forth. You know, lack of civility is thrown around. Maybe some of that has flowed off to the litigants themselves. But be that as it may, mean or tough talk or childish or whatever you want to call it, that's not prohibited communication, and it's certainly not a basis for domestic violence. These communications from the appellant if you look at the relevant cases, which we cite, one of them is Burke, B-U-R-K-U-E. Another is Evil Sizer in our papers. Those were cases where the communications were personal and threatening. The one person, I want to get back to you and be in love again, and essentially threatening to show up at the house. And Evil Sizer was a case where the one spouse unlawfully pirated all the data off the other spouse's cell phone and distributed it to people far and wide. Those cases have nothing to do with the situation here, and we don't find any case that would hold on similar facts that this type of communication we have here amounts to domestic violence. And then you have the Hansen case, which I reviewed a moment ago. The other thing, if you look at the test for DVRO, it talks about obviously physical violence or threat of violence or harassment. I mean, communications, confrontations between the people physically is one thing. And then you get to just communications, whether it's email, letter, handwritten notes left somewhere, that type of thing. And then Family Code 6320C, like Charlie, talks about disturbing the peace of the other party can be domestic violence, but the test is reference to the totality of the circumstances and whether there's a destruction of the mental or emotional calm of the other party. I'm paraphrasing there, but that's what the statute says. Well, parties in litigation receive communication from their opponent. Often it's disturbing. By its nature it is, or it's meant to be, perhaps. But that doesn't mean that it's domestic violence. And if you look at the totality of the circumstances here, I think there's a couple of very important facts which are in our papers and then cited to the record. And that is that Ms. Bassi was writing email to her ex-husband about these subjects, the family law proceedings so long drawn out, how it was adversely affecting their family, her point of view on that. She was writing about the seed, what we called the seed RICO, separate litigation or threatened litigation that involved what were formerly community property businesses. She refers to all of that. It took 1 year for ex-husband respondent Mr. Bassi to suddenly say, oh, this is now domestic violence, these emails. And curiously, at the 1 year mark was when his attorney, he received indication that Ms. Bassi was preparing a RICO complaint for essentially alleged consumer protection law violations having to do with agriculture. That's when he suddenly decided that these emails were domestic violence. A couple other things to note. He said, well, she's writing about my significant other, Ms. Marjorie Russo. Our papers make clear Ms. Russo was involved in the seed company businesses as a bookkeeper. She was actually worked as a paralegal in family law, had other connections to the case. She just wasn't the uninvolved significant other. And the comments that were made about her in writing had to do with her involvement in the family law litigation or the RICO case. So all of these things together as totality of the circumstances have to lead to the conclusion that this simply wasn't credible threat of violence. It wasn't domestic violence. It was, you can have your point of view that it was trite, that it was childish, that whatever you want to call it. But this is what happens in litigation. People say things and get emotional and what have you. And what the respondent is asking the courts to do in the future is to parse through communication between warring spouses or litigants in general, whether it's DVRO or civil harassment, and try to figure out if the email is just too mean. Well, we don't need that. There's no such test that's relevant or important. We already have a test, and that is the writing has to threaten violence, a credible threat of violence. And I think, as we hear sometimes, that's something you know it when you see it. I'm going to kill you. I'm going to show up at your house. I'm going to get your girl, whatever it might be, words to that effect. There's none of that here. It's simply not a case of domestic violence. It is anti-SLAPP protected. It was part of litigation, and the petition should be granted and the trial court reversed. Thank you.
Thank you very much, Mr. Evans. We will reserve the remaining time for your rebuttal. And yes, go ahead. Please go ahead.
May it please the court. As is customary in family law cases, I will sometimes refer to the parties by their first name. No disrespect is intended. As the court knows, the anti-SLAPP statute is intended to provide a mechanism for the early dismissal of unmeritorious claims that are filed to thwart the valid exercise of the constitutional rights of freedom of speech and petition for redress of grievances. The purpose of the statute is to unmask SLAPP actions that are masquerading as ordinary lawsuits and to resolve them expeditiously. The DVR petition in this case is simply not a hidden SLAPP action. We know that because Robert does not seek to stop Susan from expressing herself about her divorce case or threatening other lawsuits against Robert. Here, the only relief Robert seeks is to have Susan stop contacting him, either in person or through electronic means. Simply put, the DVRO seeks no relief other than for Susan to leave Robert alone. Susan is free to say whatever she wants to whomever she wants, but she has no right to communicate with Robert and certainly has no right to bombard Robert with communications that destroy his mental peace, which constitutes domestic violence. The gravamen of a plaintiff's claim determines whether Section 425.16 applies. And here, the gravamen of the DVR petition is not to chill speech in general. It is to stop harassment between two parties who meet the relationship requirement for DVRO. Susan argues that so long as she collaterally mentions something about litigation in her communications, no matter how attenuated, then she can thwart the domestic violence restraining order laws because the litigation privilege protects her. This is not the law, and the goal of preventing and protecting against domestic violence is not so easily defeated. If essential injury producing conduct upon which the plaintiff's claim is premised does not rest on protected speech or petitioning activity, then collateral or incidental allusions to protected activity will not trigger the application of the anti-SLAPP statute. Here, the lower court found that several of the emails were not substantially related to the substantive issues of the dissolution action or other threatened litigation. Appellant has on multiple occasions incorrectly stated that the court only found one email was not subject to the litigation privilege. That is simply inaccurate. The order states on two different occasions that there were several emails that were not protected activity, and therefore Susan failed to meet her burden of showing Robert's DVR request arose from protected activity.
Ms. Kalamoj, if I can interrupt you here, I took Mr. Evans, the bulk of his comments this morning, to be addressing the merits of the DVPA petition itself. Would you, which is step 2 of the analysis, if you would turn to that at some point, I would appreciate it.
Certainly. So there's no right to disturb the peace of another person. The case of marriage of Evil Sizer and Sweeney recognized that the right to free speech is not absolute. Among the speech that is not protected is that which violates the DVPA under Family Code sections. Under Section 6203, subsection A4 of the Family Code, abuse is not limited to actual infliction of physical injury or assault. Further, the Family Code Section 6320, the behavior that may be enjoined is stalking, harassing, or disturbing the peace of another party. And here it's important to highlight that some of the emails were to other third parties and were copied to Robert. And in fact, I will skip that part because we'll focus on the second prong. Appellant's brief admits that the purpose of her emails to Robert was to get under the skin and to make him uncomfortable. Appellant goes even so far as to say, quote, much litigation communication has that prick purpose to make the opponent uncomfortable. A settlement strategy to make the other side upset, nervous, or worried is typical and often necessary and effective to effectuate a settlement. That's at page 28 of Appellant's opening brief. When you compare Susan's admitted intent to what courts have said about what actions disturb the peace of another party, that is the conduct that destroys the mental or emotional calm of the other party, as stated in Marriage of Davila and Mejia, and unwanted course of conduct, as stated in Marriage of Ned Carney, it is clear that Susan's emails were designed to disturb Robert's peace and ultimately have the desired effects. As a final point, Appellant's brief cites the case of Hansen versus Volkov, a case that was decided in September of last year by the Court of Appeal, 2nd District, Division 7. Appellant essentially argues that under Hansen, the email sent by Susan would have to include a threat of violence in order to be found to have disturbed Robert's peace. That is not the law, and appellant's reliance on this case is unsound for several reasons. The first being that the Hansen case involved a civil harassment restraining order, which has a higher burden of proof, and what constitutes harassments under CCP 527.6 is categorically different than what constitutes domestic violence under the DVRO statutes. For a civil harassment, the course of conduct must be that which would cause a reasonable person to suffer substantial emotional distress and must actually cause substantial emotional distress to the petitioner. Secondly, the parties were opposing counsel in a pending dissolution matter. They had no other relation to another other than in the pending litigation. Naturally, none of the communications between the two involved matters other than litigation, and the court, for obvious reasons, found that the emails to be constitutionally protected litigation activity. Robert and Susan here are not opposing counsel, whose only connection to one another is through pending litigation. Further, as the trial court found, not all the communications were substantially related to the substantive issue in the litigation. The trial court's ruling denying the anti-SLAPP motion was correct and should be affirmed.
All right, thank you for your comments. Mr. Evans, I'm just seeing no questions from my colleagues. Mr. Evans, please go ahead.
Thank you, Your Honor. We all know that clients can talk to each other regardless of representation by counsel. In fact, that's a pillar of litigation. The parties involved need to talk, need to communicate. However, if one party takes the position, I don't want to hear from my opponent, whether it's a soon-to-be ex-spouse or business partner formerly, I don't want to hear from that opponent. The remedy is to tell your attorney, please instruct that the other party is not to contact me. The remedy is not to run to court and ask for domestic violence restraining order. Now here, when you get into the facts or the weeds as to how this went down, it was complete confusion. The counsel for Mr. Bassi wrote an email to Ms. Bassi's then attorney, who's an elderly gentleman and not versed really in email and so forth, and Martinez knew that. And so there was a slip up in communication, and the sort of instruction, if you will, Susan, please, is to stop contacting Robert. That got lost in the fray for several days. And in that interim period, Susan contacted Mr. Bassi again. But after she was advised that this was Mr. Bassi's wish and desire, that he didn't want to hear from her anymore, she stopped. If that communication had been done correctly in the first place, then there'd be no reason for a DVRO. As far as the trial court's ruling, it refers specifically to the one email I quoted from earlier. It's on page 20 of our opening brief. It sort of backhandedly refers to several other emails, and we don't know which ones. And if you look at these emails, and if you take the one that the court did specify at page 20, and you go to the next page of our brief, 21, we go through and explain exactly what that email was about. It would be Greek to most people because you're not in the litigation. You don't know who these people are, but it was about litigation. And the idea that litigation speech, can't be mean or incisive or what have you. I mean, these things happen all the time. One party says to the other, "You're going to lose." That witness, Mr. Smith, he's a no good. He lied over in such and such a proceeding. All these types of things are said. Now, are they true or not true? If they're not true, maybe there's a remedy to sue for defamation if it's not privileged in litigation. But DVRO or civil harassment, and I don't think for the purposes of this case there's much difference. I'll disagree with my esteemed colleague. But for purposes of just straight up communication, email, letters, to get to domestic violence, it has to be something that you know it when you see it. I'm going to kill you. I'm those sorts of things. The Evil Sizer case involved essentially a physical intrusion, taking data from someone's phone and disseminating. There's no physical aspect to this whatsoever. You know, the typical harassment. They come to my house. They stalk me. They threaten me. You know, in person. None of that is here. We're talking strictly about a writing, a communication that's in black and white. And Mr. Bassi, he was unnerved by it. It disturbed him. Well, then maybe it was effective communication in terms of having him think about how litigation, particularly family law litigation, how that is disturbing and needs to stop. Are we, is the court going to dissuade people from this type of communication? Are we going to put the clampers on the ability of warring spouses, other litigants, to talk forthright with each other and maybe it gets mean? No, we can't go there. And that's what the Hansen case says. There's just no basis here whatsoever to find that these written communications were domestic violence. And you're right, Your Honor, I'm kind of on to slap test 2 because I think test 1 is clearly met. These all arose in the context of litigation. They mention people, witnesses, events, circumstances that are occurring in the litigation, whether it's the family law proceeding or the threatened RICO seed case. It's all in litigation. That's why we don't need to address prong 1. But prong 2, there's just nothing here. And all this has done is prolonged this family law litigation, consumed more resources of the courts and counsel and everyone else for nothing. And had there just been a proper communication at the beginning, don't tell your client not to contact my client anymore, presumably we wouldn't be here. The petition, Your Honors, needs to be granted and this trial court ruling overturned. Thank you.
Thank you, Mr. Evans, and thank you to both counsel. Again, I want to thank you for your patience today. The court is grateful for it. And I want to thank our courtroom staff as well for a very long morning. We really appreciate your professionalism this morning. And with that, the court is in recess. Thank you. And the matter is under submission. Thank you.